Hello everyone. We have already completed the company law portion of chapter 4. Now we will be dealing with SFIO. So what is SFIO, which is in slide number 11? It's Serious Fraud Investigation Office. So before we start with this particular slide, I should just give you an overview that this is a kind of investigation authority that has been brought under company law, which deals with investigation of serious fraudulent crimes committed by senior executives of large organizations. It is a multidisciplinary organization having requirement of experts from various fields such as corporate law, criminal law, banking, accounting, forensic audit, capital markets, taxation, etc. Okay, before I say why this SFIO needs experts from these different fields, let me just explain that when a corporate fraud is committed, it is not limited to a specific like branch, like the fraud is only of audit in nature or banking in nature. So this kind of investigation office have experts from different fields, just the fields I had mentioned before. It was set up on the recommendation of a committee headed by Naresh Chandra, a former cabinet secretary on corporate governance, in order to tackle serious crimes related to corporate financial fraud. So you can see this SFIO has been completely brought on the recommendation of this particular committee. And remember the full form of SFIO, it's Serious Fraud Investigation Office. You might get a lot of questions on this particular topic in your competitive exams. So section 211 of Companies Act 2013 talks about establishment of this SFIO. SFIO is a multidisciplinary organization, just the thing that I was talking about, having the primary task of investigating white collar crimes in the company. So remember, what is its primary task? To investigate these white collar crimes which are committed in the organizations or companies. It has requirement of experts from various fields such as corporate law, criminal law, banking, accounting, forensic audit, capital market, taxation, IT, etc. Just the thing I had talked before. So it's the same thing. It was established after receiving approval from the central government on 9th January 2003 under the jurisdiction of MCA, which is Ministry of Corporate Affairs. It has its headquarters in New Delhi. Headquarters in New Delhi, remember. However, the regional offices are in Mumbai, Hyderabad, Kolkata and Chennai. So now you can understand how this SFIO is very much relevant to investigate in this big corporate frauds or matters of white collar crimes in the companies or organizations. Yes, so now we are in slide 12, which deals with section 212 of Companies Act 2013, which is investigation by SFIO. So according to this section, any matter may be referred to SFIO by the central government. So remember, who refers the matters to a SFIO? Basically the central government. Number one, where the registrar of companies or ROC or an inspector sends a report to the MCA under section 208 of the Companies Act 2013, and further investigation into affairs of the company is necessary in such cases. So in point number 1, it has been stated in what kind of cases or through which section a matter can be referred to the SFIO, by whom? By the ROC or an inspector. In the form of a report, it has to be sent to SFIO. Where the resolution passed by a company demands that such investigation needs to be performed. So the resolution should state that such investigation needs to be performed, only then can a SFIO be involved. Point number 3, where it appears to be in the greater public interest. So then SFIO can be involved by the central government. Point number 4, where there has been a request made by the central government or the state government for the same. So the fourth point is self-explanatory. Now in slide 13 and onwards, we will be talking about the amendments that have been introduced with respect to the power to arrest of SFIO, which has been very recently done. So as we can say in 2017. So point number 1, the amendments were introduced by MCA of course MCA, because MCA is majorly the governing body, through a notification issued on 24 August 2017 in the form of companies. Arrest in connection with investigation by Serious Fraud Investigation Office, Rules 2017. So this amendment has been brought by Company Act Rules or Company Rules 2017, introduced under subsection 8 to 10 of section 212 of the Companies Act in order to increase the working efficiency of SFIO. Before this, SFIO had very limited power to arrest, or actually if we say practically no power to arrest at all by a SFIO was there. So through this amendment, the power to arrest has been increased. Point number 2, the notification lays down that in cases of other than government companies, an arrest can be made on basis of material information possessed by director or additional director or assistant director of SFIO by a general or special order if he believes that the person under investigation is liable to arrest under section 212 subsection 6 and must inform the reason for the same to that person. So this is just like a CRPC provision basically. Further, the section 212 subsection 9 and section 212 subsection 10 lays down the procedure for making such an arrest. So the next point regarding the amendment, in case the matter, which is in slide 14, so refer to slide 14, in case the matter is involving a government or foreign company, such an arrest must be made with prior approval of Government of India, and managing director of that company must be informed of such an arrest. Of course, because a foreign company, jurisdiction is of another country. So before the SFIO, before you think that the SFIO makes an arrest, it of course has to take the prior approval of Government of India. So the next point, after the arrest, the procedure followed is similar to that of CRPC, as I was saying you just before this slide. That is, producing the arrested person before a judicial or metropolitan magistrate. So who? Judicial or metropolitan magistrate within 24 hours of such arrest. So please refer to slide number 15. Eminent cases of investigation under SFIO. The Satyam scam case is one of the biggest case where you can see the involvement of SFIO, where SFIO had investigated the Satyam scam and reasoned that the independent directors of Satyam were not engaged with the multi-crore bookkeeping misrepresentation in the IT organization and were kept oblivious by the chairman himself, Ramalingam Raju. So you will read about Satyam scam later in the last module there. Also there was this case, Deccan Chronicle Holding Limited, DCHL case. SFIO has charged debt-loaded newspaper publisher Deccan Chronicle Holdings and its directors with infringement of as many as 20 sections of the Companies Act. So these are the major cases where we see SFIO's involvement basically. So now the next legislation, we have talked about Company Laws 2013, we have talked about SFIO under which is a wing of MCA, to investigate the matters of white collar crimes in organization. Now we come to Reserve Bank of India Act 1934. Before we study the acts which have been mentioned further, so before that I would like to point out just a single thing, that this corporate criminal liability in totality do not have a dedicated legislation. Hence, many legislations comes into purview in this kind of crimes. So, Reserve Bank of India Act 1934, before going into it, let us just see what are the major functions of RBI. So, RBI is a monetary authority that we all know, regulator and supervisor of financial system, manager of foreign exchange. Then we have issuer of currency, developmental role it has, banker to the government and banker to all banks. So you see these are some of the listed functions, the major functions I should say of RBI. We will be in the next slide, we'll be studying different sections that RBI has to curb this kind of corporate crime. So we come to slide 17, where there are provisions of the RBI Act relating to the offences of frauds committed by organizations. Now there have been these 4 sections that I have listed out, wherein I'll be talking about the penalties, but in a very brief manner, because section 58B of RBI Act is like it's there are relevant as well as irrelevant things, but then just a gist of it is that whoever in any application, declaration, return, statement, information or particulars made, required or furnished by or under for the purposes of the provisions of this act, meaning thereby RBI Act or any order, regulation, all this, if he willfully makes a misrepresentation in the prospectus or say in the advertisement for getting investments, if he does so, or if the company does so, then in that case or willfully omits to make a statement which is false in any material particular, all this, in this case he or she shall be punishable with imprisonment for a term which may extend to 3 years and shall also be liable to fine. Again, if in the bookkeeping method, if someone willfully ignores or omits or commits a misstatement or thing like that, so that there is a manipulation of statement, he shall be punishable with fine which may extend to 2,000 rupees in respect of each offence. And if he persists such kind of offence or there is a refusal, then there will be a further fine of 100 rupees every day for the after the first, during which the offence continues. So these are the kind of if there is a misrepresentation or anything made in any of the documents of a company, such kind of punishments are given. So the next section, which is section 58C, which states the offences by companies. So in this case, in this particular section, there is 2 types of things that is mentioned, like wherein there is a protection that is given to people who are willfully not involved in a crime. They did not have the information of such a crime being committed under their nose. So in that case, they are given a protection under subsection 1, and subsection 2 states wherever there is a crime that has been committed by the key managerial persons, and if it has been proved, then they will be accordingly punished, and any offence in this case under this act shall be deemed to have been committed at the place where the registered office or the principal place of business is there. So this section you need to read in thorough. That's there in the module, or you can just Google this section. It will be easier for you to remember. So the next section, which is section 58E subsection 1, basically of the Reserve Bank of India Act, talks about which court is going to take the cognizance in case of a crime is committed under the above mentioned sections. So subsection 1 states, no court shall take cognizance of any offence punishable under this act, except, just remember after this, except upon a complaint in writing made by an officer of the bank, generally or specially authorized in writing in this behalf by the bank, and no court other than that of a metropolitan magistrate or a judicial magistrate of the first class or a court superior thereto shall try any such offence. So this you need to remember very well. So the next section, which is section 58G in the Reserve Bank of India Act 1934, which actually talks about the power of the bank to impose fine. Now in this section, the quantum of fine will be imposed. What quantum of fine in case of a contravention is being talked about, whether it will be 5 lakh or whatever, it's being decided under this section. Also there would be a notice that needs to be served to a non-banking financial company, the process it is being mentioned here, and a reasonable opportunity like the principles of natural justice is followed here, when a notice is served and a penalty to be imposed. So again, also subsection 3 talks about the limitation period from the date of the notice, like when the penalty has to be paid and what are the procedure. Everything is there in this particular sections. Of course you can Google it as well as refer to the module. So I think this covers the portion of our RBI Act.